Welcome to the Deep Dive, where we take complex information, plunge right into the source material, and really pull out the insights that matter most to you. In this deep dive, we're focusing on a really crucial area, often quite sensitive too. Children and local authorities under UK law. We're using detailed materials that lay out the whole statutory framework and the principles guiding when and how the state should step into family life.
Yeah, and this deep dive is specifically designed for educational purposes. We want to give you a really thorough overview of the duties, the powers, and, crucially, the protections built into the law for children who are considered in need.
It's about understanding that legal structure.
Exactly. It governs some incredibly sensitive situations.
And we absolutely want to give credit where it's due. The materials we're digging into today, and they've been very generously made available by the University of London for students studying this vital subject.
That's right.
And this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
And look, to all of you out there studying this, maybe preparing for an exam, well, good luck. We really hope this helps you get to grips with the core principles and the key case law. They're fundamental, really.
Definitely. So our mission today is to unpack all of this. We want to make sure you understand the core duties local authorities have, the different kinds of intervention available, how those crucial legal decisions get made, and critically, how the law, we're talking mainly the Children Act 1989 and the Human Rights Act 1998, how that shapes this whole relationship, the state and the family.
Yeah, and the source material makes it clear this is not an easy field for the professionals involved.
Yeah.
Social workers, judges, commentators like Herring point out some massive challenges they face constantly.
Such as?
Well, first off, just gathering reliable evidence. It's incredibly difficult in private family situations. Lord Nichols himself, he talked about judges having to try and penetrate the fog of denials, evasions, lies, and half-truths. It's often like that. Professionals have to make these critical judgments, often based on incomplete or conflicting information about what's really happening behind closed doors.
That sounds unbelievably tough, trying to find the truth, assess risk, especially when families themselves might be really struggling or vulnerable. What else?
Okay, secondly, there's this fundamental ethical question and a practical one too. How much does a child have to be suffering or be at risk of suffering before the state stepping in is legally or even morally justified?
Right, where's the line?
Exactly. Where is that line between parenting that maybe society thinks is poor and parenting that actually requires legal action? Is a messy house enough? Probably not. An unhealthy diet on its own? Unlikely. There's no easy answer, and people have very different views.
So that constant debate about the threshold for intervention, that's a huge challenge in itself.
It is. And thirdly, even when abuse or neglect is proven and protection is clearly needed, deciding the right way forward for the child. That's hugely complex, too.
Because removing a child might seem necessary for safety?
Essential, sometimes. But placing them in local authority care, well, that brings its own concerns. Quality of care, stability. There's a risk, as Herring notes, that you could end up heaping harm upon harm if the alternative care isn't right for that child.
And running through all of this, I imagine, is the issue of resources. Funding.
Always. The ability of local authorities to provide the support needed, whether it's prevention or intervention, depends heavily on funding. And that forces some really difficult choices about where money gets spent.
So those are the real-world pressures. But the legal framework, that's what provides the structure for trying to navigate these things.
That's the idea, yes.
So let's unpack that legal structure then. Where do we start? What are the foundational ideas, the sort of philosophy behind the main piece of legislation, the Children Act 1989?
Okay, the Children Act 1989, you'll hear it called the CA 1989. It was a massive overhaul of UK child law. And it's built on 4 really key principles. You absolutely need to get your head around these because they influence everything else in public child law.
Right, 4 principles. Let's dive in. What's the first one?
The first is non-intervention. The law starts from a place of, well, real respect for the family as an independent unit. The core idea, Lord Mackay talked about this when the act came in, is that the state shouldn't interfere in family life unless it's absolutely necessary.
Holding back unless essential.
Precisely. Compulsory measures, that means state action against the family's wishes, they can only happen after a court order. And that court order, it can only be made if a very specific threshold test set out in Section 312 of the Act is proven.
Section 312, threshold. Got it.
Yeah. And local authorities can't just use other legal routes, like the old power of wardship, to get around that threshold. Also, courts generally can't force an authority to start care proceedings, even if they're worried, though they can order an investigation under Section 37 to see if action is needed.
So the burden is on the state, to justify interfering based on that strict legal test. Principle 1, non-intervention. What's number 2?
Second principle, support for families in difficulty. The CA 1989 isn't just about stepping in when things go wrong. It's fundamentally about trying to prevent problems escalating to that point.
Proactive rather than just reactive.
Exactly. It aims to provide support services to families who are struggling, who are in need, to help them cope and hopefully stop situations deteriorating further.
Makes sense. Prevention is better than cure, if possible. And the third principle.
Third is partnership between local authorities and parents. This was a big philosophical shift. Even when concerns arise, even when intervention is needed, the law encourages authorities to work with parents where possible, not just against them.
Collaboration.
Yes, parents keep their parental responsibility. The authorities' powers, even when a child is looked after, that means in their care, we'll get to, that those powers should be used in partnership. The authority can only limit how a parent uses their responsibility if it's necessary for the child's welfare. You see this emphasis in official guidance, too.
Working together sounds more effective. And the fourth principle.
Fourth principle is maintenance of links between the child and the family. Even if a child has to be accommodated or is under a care order and living away from home, the law says efforts must be made to keep connections going with their family, parents, siblings, others, as long as it's appropriate and safe for the child.
Keeping those bonds intact where possible.
Yeah. The hope is always for possible reunion if it's safe, or at least for the family to still play a positive role. It recognizes how important family ties are for a child's identity and well-being.
Okay, so those 4 principles are the absolute bedrock. Non-intervention, hold back unless threshold met, support, help families early, partnership, work with parents, and maintenance of links, keep families connected. Got it. Anything else that builds on this 1989 Act?
Yes, the Children Act 2004, CA 2004. It's important supplementary law. It came about partly after the tragic Victoria Climby case and the inquiry that followed, which found serious failures in how agencies work together.
Right, I remember that case. Awful.
It was. So the 2004 Act puts a big emphasis on better joint working and information sharing between everyone involved with children, health, schools, social services, police, you name it. It also set up the Children's Commissioner for England, whose job includes promoting the UN Convention on the Rights of the Child. But remember, the 2004 Act supplements the 1989 Act, especially on cooperation. It doesn't replace its core principles.
Okay, so better teamwork is the key message from 2004. So the overall philosophy seems clear. Support families, work in partnership, only intervene when that Section 31 threshold is met, and keep families connected where possible for the child's welfare. Right then. With that philosophy set, let's look at the actual duties local authorities have before we get anywhere near compulsory orders. This is about that support principle in action. Where does the law start?
It starts with the very broad general duty under Section 17 of the Children Act 1989. This is the foundation for providing support, and it applies specifically to children in need in the authorities area.
Children in need.
Yes, and the duty laid out in Section 17.1 has 2 parts. First, Section 17.1, to safeguard and promote the welfare of those children. Second, Section 17.1b, consistent with that, to promote their upbringing by their families by providing suitable services.
Okay, children in need. That sounds like a term we really need to pin down. What's the legal definition?
It is. Absolutely crucial definition. Section 17.10 tells us a child is in need if one of 3 things applies. 1, they're unlikely to achieve or maintain a reasonable standard of health or development without services. 2, their health or development is likely to be significantly impaired without services. Or 3, they're disabled.
And does disabled have a specific definition too?
Yes, it's also defined in Section 17.10. It includes being blind, deaf, dumb, having a mental disorder, or being substantially and permanently handicapped by illness, injury, congenital deformity, or another prescribed disability. And Section 17.1 clarifies that development covers physical, intellectual, emotional, social, or behavioral development, and health means physical or mental health. You need to know these definitions.
Right, so the duty is owed to children fitting those descriptions. How does the authority actually do this? How do they fulfill this Section 17 duty?
Well, Schedule 2, Part 1 of the Act adds more detail. It talks about identifying children in need and providing services appropriate to those needs. Importantly, they can also arrange for others to provide services, Section 17.5. They don't have to do everything themselves.
So they can commission services.
Exactly. The help can be practical things, assistance in kind, or exceptionally, cash, Section 17.6.
Hmm.
Assistance might have conditionals attached, Section 17.7, and it's generally means tested, Section 17.8, although families on certain benefits don't have to repay, Section 17.9.
So it's a broad duty to identify needs and provide or facilitate support, potentially including financial help. But can a family go to court and say, you must give us this specific service under Section 17?
Ah, that's a really key point. Generally, no. Section 17 is about the authority's powers and duties towards children in need as a group. It doesn't create a direct, enforceable right for an individual child to demand a specific service. That was established in cases like R.V. Barnett, LBC.
So it's not like a shopping list of entitlements.
Not really. Courts are very reluctant to interfere with how authorities allocate their limited resources under this broad duty. It's seen as the authority's job to decide the best way to meet needs within their budget.
Okay, broad duty, lots of discretion on what services, but not an individual right to demand a specific thing.
Yeah.
But can you challenge how they make their decisions under Section 17?
Yes, you can. While you can't demand a specific service, the process by which the authority makes its decision is subject to judicial review. If they failed to follow proper procedures, didn't ask the right questions, didn't get enough information, acted irrationally, then a court might intervene. We see this in cases like Reese's application for judicial review and RGV Southwark LBC. Historically, suing for negligence or breach of statutory duty in this area was very tough. Think TP and KMV UK, UV Bedfordshire CC. Courts worried about opening the floodgates to litigation. There's maybe a slight shift now, but that concern is still there.
So, a crucial distinction for anyone studying. The duty is broad, not a specific right, but the decision-making process can be legally challenged via judicial review.
Got it. Now, Section 17 covers support services. What about when the need is more fundamental, like a child needing a place to live? Does the authority have a duty to provide accommodation?
Yes, the general duty under Section 17 also encompasses providing accommodation in specific situations. This is primarily regulated by Section 20 of the Act, and this is what's usually called voluntary accommodation.
Voluntary accommodation under Section 20. When does this duty kick in? Section 21 says a local authority shall, meaning they must provide accommodation for children in their area who seem to need it because of one of three reasons. 1, there's no person with parental responsibility for them. 2, they are lost or abandoned. Or 3, the person who is caring for them is prevented from providing suitable accommodation or care.
Like if a parent is seriously ill or imprisoned.
Exactly. Could be temporary, could be permanent, any reason why the carer can't provide a home. This duty applies to children under 18, although for those 16 or over, Section 23 adds a condition. The authority only must accommodate if they think the child would be seriously prejudiced otherwise.
So for a child under 16 whose carer is suddenly unable to look after them, the authority must provide accommodation. Does this Section 20 duty replace the broader Section 17 duty?
No, they exist side by side. The broad discretionary Section 17 duty underpins it. When the specific circumstances in Section 21 are met, that general duty crystallizes into the specific mandatory duty under Section 20 to accommodate. The Supreme Court confirmed this in RGV Southwark.
Okay, Section 20 is a specific application of Section 17 when accommodation is needed. What if the authority decides not to accommodate, maybe using discretion for an older child? Can that be challenged?
Yes. Even where they have discretion, like under Section 24 and 5, for young people up to 21 if it promotes their welfare. A decision not to accommodate can still be challenged through judicial review. Cases like RGV Southwark again and RGV Barnett show that these decisions aren't beyond scrutiny if the process was flawed.
So mandatory duty sometimes, discretion sometimes, but always reviewable. You keep calling it voluntary accommodation. What's the voluntary part?
This is the absolute crux of Section 20. It's voluntary because the local authority cannot provide accommodation under Section 20 for a child under 16 if someone with parental responsibility objects and is willing and able to provide a home.
So a parent can block it?
Yes, if they have PR and can offer care. And even more critically, Section 28 states that a person with parental responsibility can remove a child under 16 from Section 20 accommodation at any time, without needing permission, without notice.
Wow, at any time.
At any time. Now, if there's a court order, like a residence order already in place, only the person with that order can object or remove, Section 2900. And kids age 16 or over can decide for themselves if they want to be accommodated, Section 2011.
That right to remove a child under 16 anytime is a massive feature. How are these Section 20 arrangements usually set up in practice?
Well, ideally, local authorities and parents reach written agreements about the terms. Regulations suggest what these should cover. And before providing accommodation, the authority also has a duty, under Section 26, to find out the child's wishes and feelings as far as possible and consider them.
It sounds like it should be straightforward and collaborative, but didn't you say there were concerns about how Section 20 gets used?
Huge concerns. President Munby, in a very significant case, Re-N Children, 2015, was scathing about some practices he'd seen. He flagged four big problems.
Which were
1. Failure to get proper informed consent from parents initially. 2. Really poorly drafted agreements. 3. Arrangements just drifting on for months or years, becoming long-term care without any court oversight. And 4. Authorities being slow or reluctant to return children immediately when parents ask for them back, despite Section 28.
He didn't mince his words, did he? He laid out guidance, too.
He did. Very clear guidance on good practice. Get consent in writing. Make sure the parent understands it. Make sure it explicitly states the Section 20 right to remove at any time. Don't try to limit that right. Provide translations if needed. He said misuse of Section 20 was a denial of rights, and it must stop. A later case, Herefordshire Council VAB 2018, shows these issues persist.
It must stop. Very strong. So does that mean written consent and these agreements are now legally required for Section 20?
Now this is where it gets legally fascinating and maybe a bit counterintuitive after Munby's judgment. The Court of Appeal in London Borough of Hackney v. Williams 2017 looked purely at the words in the Act. They pointed out the word consent isn't actually in Section 20.
Really?
Really? So they concluded there's no express statutory requirement for an authority to get positive parental consent, let alone written consent or all the specific details Munby recommended.
But that seems to fly in the face of the Re-N guidance.
It does, in terms of legal obligation versus best practice. The Court of Appeal said Munby's points are good practice, absolutely, but they shouldn't be treated as hard rules of law. To sue for damages, say under the Human Rights Act, you need to show the authority breached the statute itself, not just that they fell short of later good practice guidance. The Supreme Court agreed with this in Williams v. Hackney 2018.
Okay, so good practice,
Yeah.
strongly encouraged, legally vital maybe for defending decisions, but not explicitly mandated by the statute in the way Munby suggested. Proving a legal breach is therefore harder if it's just about lack of written consent. Sounds like Section 20 remains a tricky area, like in Worcestershire County Council VIA 2019.
Exactly. The principles are there, but the practicalities and legal challenges around Section 20, especially consent and duration, are ongoing. It's a complex interface between voluntary support and state power.
Okay, so we've covered the general duty under Section 17 and voluntary accommodation under Section 20. What about when children are more formally in the local authority's care? Not just voluntarily accommodated, but maybe under a court order or for longer than a day.
Right. That brings us to the duties towards children looked after by the authority. This specific legal status is set out in Section 22 of the CA 1989. A child is legally looked after if they've been accommodated by the authority under Section 20 for more than 24 hours, or if they're subject to a care order.
So even an overnight stay under Section 20 makes them looked after. What's the core duty owed to these children under Section 22?
Section 22(1) imposes a clear duty. The authority must safeguard and promote the looked-after child's welfare. And, interestingly, they must also make use of services available for children cared for by their own parents, if that seems reasonable for the child, trying to normalize their experience where possible.
Safeguard and promote welfare. How do they make decisions about these children? Who do they have to consult?
Section 22(3) is key here. Before making any decision about a looked-after child, the authority must, as far as reasonably practicable, find out the wishes and feelings of several people.
Who's on the list?
The child themselves, obviously, their parents, and that includes putative fathers, even without PR, anyone else with parental responsibility, and, crucially, Section 22(4) adds any other person whose wishes and feelings the authority consider to be relevant.
Any other person.
Right.
Relevant. That sounds potentially broad. Who might that be?
Guidance suggests it could be quite wide. Think GP, school, extended family members, the child's guardian, if appointed by court, maybe a worker from a voluntary agency involved, even former foster carers, anyone significant in the child's life. And building on that duty to consult, Section 22(5) says the authority has to make its decision considering several things: the child's age, understanding, wishes, and feelings, the wishes and feelings of parents and PR holders, and also the child's religious persuasion, racial origin, and cultural and linguistic background.
So decisions have to be child-focused, culturally sensitive, and informed by consultation. Are there specific rules about where looked-after children should live?
Yes, Section 23 adds specifics about accommodation, reinforcing that maintenance of links principle. Unless it's not reasonably practicable or conflicts with the child's welfare, the authority should try to arrange for the child to live with family, Section 23(6). They should also try to accommodate them near home, and importantly, with their siblings, Section 23 some. And for disabled children, the accommodation must not be unsuitable for their needs, Section 23(8).
So keeping families and communities connected remains a priority, even when a child is formally looked after. Now, shift gears slightly. What happens if an authority gets a referral or develops concerns during voluntary support, but the child isn't looked after yet, and it's not necessarily an immediate emergency?
That's the trigger for the Section 47 investigation duty. If an authority gets information suggesting a child might be suffering or at risk of significant harm, maybe from a teacher, doctor, police, or just from their own work under Section 17, or if the child is already under an EPO or police protection, Section 47 says they must make inquiries. The aim is to decide if they need to take any action to safeguard or promote the child's welfare.
Section 47 investigation. What does that actually involve? What do they do?
They have to take reasonable steps to find out what's going on. That usually means trying to see the child unless they feel they already have enough information. If they're denied access to the child or can't find them and they think it's urgent, they can apply for a court order.
What kind of order?
Well, the source material suggests the preferred route, if the main goal is assessment, is a child assessment order, CAO, under Section 43. But if it's really urgent, access is being blocked, and they suspect significant harm, they must apply for an emergency protection order, EPO, under Section 44.
So Section 47 is the duty to investigate when concerns arise, potentially leading to court applications like CAOs or EPOs if needed to get information or ensure safety. Okay, you mentioned child assessment orders, CAOs, and emergency protection orders, EPOs, as tools linked to Section 47 investigations. Let's dig into these investigatory and emergency measures. First, the CAO. What's its purpose?
Right. A child assessment order under Section 43 is fundamentally an evidence-seeking order. The local authority or the NSPCC can apply. The court can grant it if they suspect the child is suffering or likely to suffer significant harm, and an assessment is needed to figure that out, but it's unlikely to happen without a court order compelling it.
So if parents are refusing assessment.
Exactly. It overcomes that refusal. Importantly, a CAO can't be made if the situation is so serious it actually justifies an EPO. And usually the parents have to be notified of the application.
What does the CAO actually let the authority do?
It lasts for a maximum of 7 days. It orders the parents or whoever has the child to produce the child and follow directions for assessment. It authorizes the assessment. It can even authorize removing the child from home, but only for the assessment itself. It's not for placement. Case law, like RECAI, Child Assessment Order, gives guidance on its use. After the assessment, the authority decides the next steps may be monitoring a protection plan or starting care proceedings if harm is confirmed.
Okay, CAO get information via assessment. What about the EPO? Emergency Protection Order. Sounds much more serious.
It is. An EPO, under Sections 44 and 45, is for immediate urgent protection. Anyone can apply, even ex parte, without notice in extreme urgency. The court needs to be satisfied there's a reasonable cause to believe the child is likely to suffer significant harm if not removed or kept safe where they are. Or if the ALA and SPCC are doing a Section 47 check and suspect harm but are being denied access, that can also be grounds.
A very high threshold.
Yeah.
Immediate risk of significant harm. What powers does an EPO grant?
It orders anyone who can to produce the child. It empowers the applicant, usually the LA, to remove the child or prevent removal. And crucially, it gives the applicant parental responsibility for the child while the order lasts.
Parental responsibility.
Yes, but it's limited PR. Only enough to do what's reasonably needed to protect the child's welfare, like consenting to urgent medical treatment or arranging temporary care. The court can also add directions about contact or assessment.
How long does an EPO last?
Maximum 8 days. It can be extended once for up to another 7 days, but only if the court still suspects significant harm if it ends, Section 45. They are strictly short-term measures.
Can parents challenge it?
Not in the first 72 hours. After that, the child, parents, PR holders, or former carers can apply for discharge, unless they were present at the original hearing. There are appeal rights too, Section 4510, and an EPO can lead directly to a care order if needed, Rao EP 1996. There's also a related power, an exclusion order under Section 44A. This can be attached to an EPO to remove a suspected abuser from the home, allowing the child to stay there with a safe, consenting adult tutor. A power of arrest can be added.
What about the police acting directly, before any court order?
That's police protection under Section 46. A police constable can remove a child or prevent removal if they have reasonable cause to believe the child would otherwise likely suffer significant harm. No court order needed initially. They must tell the LA parents and child quickly. A designated officer takes over.
Do the police get PR under Section 46?
No, they don't. Unlike an EPO, the designated officer just has a duty to act reasonably to protect the child. Police protection lasts a maximum of 72 hours. Case law like Langley v. Liverpool City Council suggests EPOs are preferred if possible, implying Section 46 is for real emergencies where court isn't immediately feasible.
And if the child's location is unknown in these emergency situations?
Section 48 allows the court, alongside an EPO, to order someone who knows the child's whereabouts to review them. An EPO can also authorize entry and search of premises to find the child named in the order or any other child there who might need protection.
You also mentioned injunctions briefly.
Yes. While LAs generally can't use private law orders, the court can make exclusion orders under the Family Law Act 1996 when granting an interim care order, Section 38 ACA 1989, or an EPO, Section 44 ACA 1989, removing a risky person from the home. And remember, Section 95 stops LAs applying for child arrangements orders, CAOs. If they need something similar, it's usually an injunction within public law or inherent jurisdiction. This keeps public and private law distinct mostly. Nottinghamshire CCVP stressed that contact for children in care is dealt with under Section 34, not by making care orders conditional.
And finally, truancy. Can that lead to care proceedings?
In extreme cases, persistent non-attendance at school could be a factor contributing to a finding of significant harm, Rio 1996. But usually, truancy is handled through education supervision orders, ESO, under Section 36, applied for by the Education Authority, unless it's part of a much bigger picture of neglect meeting the Section 31 threshold.
Right, so we got voluntary support, S17, S20, investigations, S47, assessment tools, CAO, S43, and emergency measures, EPO, S445, police protection, S46. When does the state move beyond these to the most serious compulsory intervention against the family's wishes outside an immediate emergency?
That's when we get to care proceedings. These can lead to the court making either a care order or a supervision order. These are the main long-term public law orders under Section 31 of the CA 1989, and the only legal basis for making them is found in Section 312.
Section 312 again, the threshold. Who applies for these orders?
The local authority, or an authorized person like the NSPCC, Section 311. They can apply on their own or during other family proceedings, Section 314. And as we said, a court can order an investigation, Section 37, but can't force the authority to apply for a care order, Nottingham CC VP Re A, care, asylum seekers. The decision to apply is the authority's. Critically, a care or supervision order can only be made if the court is satisfied that the conditions in Section 312, the threshold test, are met. Even if everyone agrees an order is needed, the court must still check the evidence against the threshold, Re A or minor, 1994. And these orders can't be made for 16 or 17-year-olds or married children, Section 313.
Okay, the threshold test in Section 312 is the absolute gatekeeper for compulsory orders. Remind us of the two essential elements.
You have to prove both of these on the balance of probabilities.
The child concerned is suffering, or is likely to suffer, significant harm.
That harm, or likelihood of harm, is attributable to either A, the care given, or likely to be given not being what it would be reasonable to expect a parent to give, or R, the child being beyond parental control.
Both significant harm or risk,
Yeah.
and D, the link to parental care or control. Let's break down those terms again. Harm.
Section 319 defines harm as ill treatment or impairment of health or development. Development covers physical, intellectual, emotional, social, or behavioral aspects. Health is physical or mental. Ill treatment includes sexual abuse and non-physical forms. The sources mention past difficulties defining sexual abuse precisely, CVC, or dealing with corporal punishment, RV, Deriviere, Re-H, and future emotional harm is definitely included, Re-B 2013.
And the harm must be significant. How significant is significant?
Judicially, it means considerable, noteworthy, or important. Humberside, CCVB. The Supreme Court in Re-B 2013 didn't give a new definition, but did say the more significant the potential harm, the less likely it needs to be for the likely to suffer test. For harm relating to health and development, not ill treatment, Section 3110 says compare the child to what you'd expect of a similar child. This means similar physical attributes, not background, which has drawn some criticism for potentially ignoring social context. Ray O. 1992. Ray O. 1992 dealt with educational development in this context.
So significant is a judgment call, sometimes benchmarked against peers. What about the timing for the is suffering part? You said is not the court date.
Correct. Crucial point confirmed by the House of Lords in Ray M. A. Minor in 1994. The relevant time is not the court hearing. Northamptonshire CCV S. 1993 clarified it's the period immediately before the state first stepped in to protect the child, maybe just before an EPO or an interim order or even Section 20 accommodation if that was the protective step.
Right, so the court looks back to the situation just before intervention started.
Yeah.
That makes sense. Otherwise, removing the child would negate the test. Okay, is suffering significant harm assessed just before protection started? What about the other option? Is likely to suffer significant harm. This is about future risk.
Yes. If the authority relies on likely to suffer, they have to prove a future risk. They don't need to wait for it to happen. The test isn't just that harm might occur on the balance of probabilities, Newham London Borough VAG. It requires proof of a real possibility that significant harm will occur, a possibility you could not sensibly ignore. It's more than a maybe, but less than certain.
And the standard of proof for showing this likelihood or the facts behind it?
It's still the ordinary civil standard, the balance of probabilities. Confirmed in Re-H&R, if you prove, on balance of probabilities, that significant harm happened to child A, that can often be enough to find it's likely, on balance of probabilities, that child B in the same home will suffer harm. But you must first prove the facts of the past harm on the balance of probabilities. Suspicion alone isn't enough. Re-H&R, Re-B, 2008.
That sounds really tricky where harm definitely happened, but you can't prove exactly who did it. The unknown perpetrator scenario.
It is very tricky. Case law helps. If harm occurred and the evidence points to it being one of the parents, but you can't prove which one, the threshold can still be met. Rio and N 2003. How courts should approach identifying perpetrators was looked at again in B. Children 2019. If the pool of possible perpetrators includes parents and another carer, like a childminder, the threshold can also be met. Lancashire CCVB 2000. But if the pool includes parents and third parties who are not carers, then the attributability part fails. Re-O 1992, Re-SH 1995.
So who might have caused the harm really matters for linking it to parental care. How does this unknown perpetrator issue affect predicting future harm the likely to suffer limb?
This is where Re-SB 2009 and Re-J 2013 from the Supreme Court are absolutely vital. Re-SB said you have to base predictions of future harm on facts proven on the balance of probabilities. You can't build a future likelihood on a past uncertainty. So just putting a parent in the pool of possible past perpetrators isn't enough by itself to say they're likely to harm another child in the future.
Right, you can't base a future probability on a past maybe. But Re-J added a nuance.
It did. Re-J 2013 confirmed Re-SB but clarified. Placing a carer in that pool of possible past perpetrators is a relevant fact. It's not enough on its own, but together with other proven facts, it can form part of the basis for finding a likelihood of future significant harm. So it's not irrelevant, it's just not sufficient in isolation. A really important distinction to grasp.
Okay, that clarifies the link, or lack of direct link, between unproven past harm and predicting future risk. Now, the second element of the threshold, attributability. Harm must be linked to care, not being what it would be reasonable to expect a parent to give, or the child being beyond control. What's reasonable care, and can a parent's personality alone be enough?
The standard is a reasonable parent. The source flags Re-B 2013 again here. The Supreme Court considered parents whose current care was okay, but they had significant underlying issues, emotional illness, character problems. The court suggested that these issues and their likely future impact on the child's emotional well-being could potentially meet the threshold even without current bad parenting.
Even if they're doing okay right now?
Potentially, yes, if the likely future emotional harm is deemed significant and attributable to those underlying parental issues. It raises that difficult question, as Headley J. noted in Re-L 2007, should the state intervene based on character rather than actual or feared abuse neglect? Society has to tolerate a range of parenting, even the barely adequate. Re-B perhaps pushes that boundary slightly.
A real tension there between protection and tolerance. So to recap the threshold, both significant harm, present or future real possibility, proven on balance of probabilities, careful with unknown perpetrators, and attributability, care below reasonable standard, potentially including future impact of character or child beyond control. Okay, let's say the court is satisfied. They've heard the evidence, applied the law, and found that both parts of that tough Section 31(2) threshold test are met. Does that mean a care order is now inevitable?
No, absolutely not. Meeting the threshold is step one. It gives the court the jurisdiction, the legal power to make an order. But then comes step two, the welfare stage, sometimes called the disposal stage.
Lawfare stage.
Yes. Here, the court decides if any order is actually needed, and if so, which order. And at this stage, the child's welfare is the paramount consideration. That's Section 1 of CA 1989. Paramount means it overrides everything else. The court must go through the welfare checklist in Section 1.3. That includes things like the child's own wishes and feelings, RARE 2015, their needs, the effect of any change, harm they've suffered or might suffer, parents' ability to meet needs, and the range of orders the court could make. They also must apply the no-order principle from Section 1.5.
The no-order principle.
Yes. It means the court should only make an order if it genuinely believes making that order would be better for the child than making no order at all. Don't intervene just because you can.
So even if the state can legally intervene because the threshold is met, the court still has to ask, should we intervene and how, based purely on what's best for this child's welfare?
Exactly. Meeting the threshold opens the door, but welfare decides if you walk through it and which room you go into. In Array Appeal, 1994, the threshold was met, but no care order was made because welfare demanded the child stay put. The court might think a less drastic option, like a supervision order, is enough. Or maybe a child arrangements order placing the child with a relative, Ray K. 1995, is better than a care order. And this welfare stage is where the Human Rights Act, particularly Article 8, Right to Respect for Family Life, really bites. The Supreme Court in Ray in 2013 hammered this home. Making a care order is a massive interference with Article 8 rights. So the decision has to be proportionate.
Proportionate.
Meaning it has to be necessary. And for a care order, necessary means it should only be made as a last resort when nothing else will do. This nothing else will do test is absolutely fundamental at the welfare stage, post-Ray B. Cases like Ray G 2013 confirmed this.
Nothing else will do. That sets the bar incredibly high for taking a child into care, tying welfare directly to human rights. What about those unknown perpetrator cases at this stage? Does the suspicion still matter?
Yes, it can. Even if you couldn't prove who caused past harm for the threshold, the possibility that a parent might have been involved can be considered when assessing future risk and evaluating options at the welfare stage, Re ONN 2003. So suspicion isn't irrelevant at this point, even if it wasn't enough for the threshold itself.
Right, so process is threshold first, S312, then welfare, S1 checklist, no order, HRA proportionality, nothing else will do. If welfare does require an order, what specific orders can the court choose from on that Section 31 application?
The court can make a final care order or a final supervision order, Section 31.5. Or, while the case is ongoing, they can make interim care or supervision orders under Section 38.1.
Interim versus final. What's the key difference there?
Interim orders are temporary holding measures, maybe while assessments are done or a Section 37 investigation is happening. They last a max of 8 weeks, potentially extended once for 4 weeks, Section 38.45. Crucially, the threshold for an interim order is lower. The court only needs reasonable grounds for believing the Section 31.2 conditions exist, Section 38.2, plus welfare and proportionality, Re-S 2010. They're for safety during the process, not for making long-term decisions, L.A. Child 2013. A final care order requires the full threshold to be met, and that conviction that nothing else will do, Re-B.
Lower bar for temporary safety, much higher bar for the final, potentially life-changing order. Makes sense. Okay, let's focus on the effects of those final orders. What actually happens when a court makes a care order?
The main effects are laid out in Section 33, the biggest one. The local authority gets parental responsibility PR for the child. But, and this is vital, the parent's PR and anyone else's is not removed. They share PR with the local authority, Section 33.45.
Shared PR. Who has the final say if they disagree?
The local authority does. They can determine the extent to which parents exercise their PR, but only if it's necessary to safeguard or promote the child's welfare. Essentially, the LA's view prevails in a conflict. But the LA's PR under a care order is also limited. They can't, for example, decide to change the child's religion against prior agreement. They can't consent to adoption. That needs a separate placement order. And they can't appoint a guardian. They can apply to remove an existing guardian. For really big decisions like changing the child's surname or taking them abroad for over a month, they need the consent of everyone else with PR or the court's permission. Section 3378. Immigration always needs court approval. Schedule 2, para top point need. A case like P, Circumcision Child in Care, 2021, shows how complex balancing parental wishes and welfare can be, even under an interim order.
So the authority gains significant power through shared PR, but it's not absolute, especially on major life decisions. How long does a care order last?
It lasts until the child turns 18, or until the order is formally discharged by the court, whichever comes first, Section 9112. And making a care order automatically ends any existing Section 8 orders, like child arrangements orders, Sections 12.2 and 91.2. The child's care falls entirely under the public law framework.
You mentioned the authority submits a care plan. What's the court's role regarding that plan?
Right. Under Section 31A, the LA must give the court its care plan before a care order is made. The court has a duty to examine that plan, especially the long-term permanence aspects, when deciding if making the care order is actually better than no order under Section 1.5. If the court really dislikes the plan, it could even refuse to make the care order, re H 2011.
So once the order is made.
Once the care order is made, the court's supervisory role generally ends. It doesn't oversee how the authority carries out the plan. Re S, Re W 2002, UKHL. But T, and it's a big but, Article 8 of the ECHR still applies. Parents have a right to be involved in the decision-making process affecting their child, including after the order is made. The authority has a duty to keep parents informed about significant changes to the care plan. In Re G 2003, the authority changed the plan drastically without telling the parents that was found to violate Article 8. Similarly, in Re DE 2014, trying to remove children placed at home under a care order without proper process was deemed disproportionate under the Re BS principles, allowing the parents to get an HRA injunction.
So the court steps back from day-to-day supervision, but Article 8 means the authority still has to involve parents in major decisions about the plan, even after the care order is granted. What about the other main order, the supervision order? What are its effects? How does it differ?
Okay, supervision order effects are in Section 35. Remember, the threshold and welfare conditions needed to make one are the same as for a care order, Section 31B. They typically last for 1 year initially, but can be extended up to a maximum of 3 years total, Schedule 3, para point 6. The child usually stays at home, placed under the supervision of a social worker.
What does the supervisor do?
Their duty is to advise, assist, and befriend the child, Schedule 3, para.9, Section 35.1a, and take steps to make the order effective, Section 35.1b. The order can include requirements like living somewhere specific or doing certain activities for up to 90 days, Schedule 3, para point 2.
So, same threshold, but how is it fundamentally different from a care order in its impact?
The absolute key difference essential to remember is that a supervision order does not give the local authority parental responsibility. A care order does, shared PR, but a supervision order does not. Win T 1994, Read D 1993, etc. None. This means the authority has far less power to direct the child's life. The supervisor can advise and require certain things, but they have no automatic right to enter the home or remove the child, even if there are serious concerns, like missed appointments or suspected abuse. Those situations would likely need emergency powers or fresh care proceedings.
That lack of PR makes it significantly less interventionist. So when would a court choose a supervision order over a care order, given the threshold is the same?
A supervision order might be seen as appropriate if the court feels the family needs support and monitoring, but the level of risk, or perhaps the parent's willingness to engage, doesn't justify the major step of the authority sharing PR. It's often used for less severe concerns, or where there's hope for cooperation but still a need for statutory oversight. The court has to weigh this carefully at the welfare stage, applying that nothing else will do test for the care order.
Right, so same entry threshold, but very different levels of state power conferred by the two orders. Supervision leaves PR with the parents. A huge issue for families when a child goes into care must be contact. Seeing their child. What does the law say about maintaining contact?
The law definitely prioritizes contact where possible. Local authorities have a duty. They must endeavor to promote contact between children they're looking after, whether under Section 20 or a care order, and their families and friends. The only exceptions are if it's not reasonably practicable or not consistent with the child's welfare. Schedule 2, para.15. Cases like Re-S, Care, Parental Contact 2004 reinforce this strong duty. They can even help with travel costs. Schedule 2, para.16.
So the starting point is promoting contact. What about when a care order is actually being considered by the court?
Before making a care order, Section 3411 requires the court to consider the LA's proposed arrangements for contact, which should be in the care plan, and let everyone comment on them. Once a child is under a care order, Section 34.1 imposes a specific duty on the local authority. They must allow the child reasonable contact with their parents, guardians, anyone who had PR before, or anyone who had a residence CAO order or wardship before the care order. What's reasonable depends on the case, of course. This duty is always subject to the authority's primary duty to safeguard the child's welfare. Children and Families Act 2014, S.7.
Can people apply to the court for specific contact orders if they aren't happy with the LA's arrangements?
Yes, the people listed in Section 34(1, parents, PR holders, etc., the child themselves, and anyone else who gets the court's permission can apply for a contact order under Section 34(2. The child or the LA can also apply to end contact, and the LA has a short-term power. They can refuse contact for up to 7 days if they believe it's urgently necessary for the child's welfare. Section 34(6).
The source mentioned some key case law about these Section 34 contact orders.
Yes, important points. Cases like Re S, A minor, 1994, established that the court shouldn't try to attach conditions like reasonable contact to the care order itself because Section 34 already imposes that duty. Also, the court cannot keep overseeing the contact arrangements once the final care order is made. Re T, 1997, Re W, 2000. Nottinghamshire CCVP and Leeds CCVC 1993 confirmed Section 34 is the only route for regulating contact once a child is in care under a care order. You can't use private law or make the care order conditional on contact.
So the LA has the lead duty. Section 34 provides the specific court framework for contact under a care order, and court supervision ends with the final order. What if someone, a parent, a child, wants to challenge a local authority decision more broadly? Not just contact, but services, accommodation, the care plan. What are their options?
There are quite a few potential avenues, sometimes described as a mosaic of accountability. No single perfect route, but several possibilities.
Okay, let's walk through some of that mosaic. What are the main ways to challenge?
Well, if there's an existing order, one direct route is applying for its discharge. Under Section 39, the child, anyone with PR, or the LA itself can apply to end a care or supervision order. The court then applies the welfare principle, Section 1, based on the circumstances at the time of the application. Recent cases like Reggie 2019 and TT 2021 stress this current welfare assessment and ECHR proportionality. A care order also ends automatically if a child arrangements order for residence is made, Section 91. Any party can seek leave to apply for a CAO residence order under Section 10, though the court must give weight to the LA's views, Section 10(9), DI, River A, Ray A, and W 1992. And the LA itself should be reviewing plans every 6 months and considering discharge, Section 26, too.
So court applications to discharge the order or get a residence order are key routes. What about less formal or administrative challenges?
There's the authority's own internal complaints procedure under Section 26 and associated regulations. It's a way to raise concerns directly with them first. RV Kingston upon Thames, RB XPT 1994. You could also ask the Secretary of State to declare the authority in default under Section 84 if they failed a duty without good reason, though that's probably rare. A major legal route is judicial review, JR. This challenges the legality of how a decision was made. Was it irrational, illegal, procedurally unfair, rather than the merits of the decision itself? You need the court's permission to bring a JR claim. The bar for showing irrationality is extremely high, basically. A decision so unreasonable that no reasonable authority could ever have come to it. RV Lancashire CC XPM 1992. Courts are often hesitant to second-guess authorities. RV Norfolk CC XPM 1989. JR is about process, not welfare. Arnezy Lambeth 2006. Then there's complaining to the Ombudsman about maladministration causing injustice. The High Court's inherent jurisdiction can be used to protect children, but Section 100 severely restricts LAs from using it. They need leave, Section 103, granted only if the result can't be achieved via other CA 1989 orders. And the child would likely suffer significant harm otherwise, Section 145. So LAs can't use it to bypass the normal routes to get care orders. However, wardship, part of inherent jurisdiction, can sometimes be used by others to challenge LA decisions about children who are accommodated under Section 20 but not under a care order. You can potentially bring civil actions, suing for negligence or breach of statutory duty. These face hurdles like limitation periods, though courts have some discretion under the Limitation Act 1980, and proving the case can be hard. The right to sue for negligence belongs to the child, usually, not the parents. Barrett v. Enfield LBC, ID v. East Berkshire. And as Williams v. Hackney showed regarding Section 20, for breach of statutory duty, you need to prove a breach of the act itself, not just a failure of good practice. And as we've touched on, increasingly significant are actions under the Human Rights Act 1998 claiming a violation of convention rights. We need to look at that specifically. Finally, while not a challenge mechanism, the National Care Standards Commission provides oversight by inspecting children's homes, etc., under the Care Standards Act 2000.
That's a complex picture of the mosaic. It shows various challenge routes exist, but some, like JR or civil actions, clearly have high legal hurdles. You've flagged the Human Rights Act 1998, the HRA, several times now, especially Article 8. How exactly has incorporating the European Convention into UK law impacted this whole area?
Its impact has been profound. The HRA 1998 means public authorities, including local authorities and courts, must act compatibly with convention rights. It gives individuals a legal basis to challenge actions or failures to act that breach those rights. A key area is the state's positive obligation to protect children from harm. If an authority knows, or ought to know, a child is at real risk of serious harm by others, like parents, but fails to take reasonable steps to protect them, that failure could breach Article 3, the right not to suffer inhuman or degrading treatment. The massive case here is ZV UK 2001. The authority knew about horrific neglect for years but didn't intervene effectively. The European Court found this failure amounted to an Article 3 breach by the state.
So the HRA enforces a duty not just not to harm, but actively to protect from harm by others. What about procedural rights for families involved in the system?
The HRA has massively strengthened procedural fairness, usually argued under Article 8, which covers the process affecting family life, or sometimes Article 6, fair trial rights. This includes parents' right to be properly involved in decisions about their child, to see relevant reports, to have effective legal representation. We already mentioned Reg G 2003, where changing a care plan without consultation breached Article 8. Other cases like Rebi 2013, Re DE 2014, Rebi S 2013, and Northamptonshire v. AS 2015, where damages were paid for Article 68 breaches, all show the HRA being used to scrutinize the fairness and justification of LA actions in court processes.
And the most direct impact seems to be on the justification for interfering with family life itself, especially making care orders.
Absolutely. The Court of Appeal said back in EHV Greenwich 2010 that courts must consider if orders infringing human rights are justified. But Re-B 2013 in the Supreme Court was the real game changer for care and adoption orders. These orders are recognized as extremely serious interferences with Article 8 rights. So Re-B established that before making such an order, the court, as part of assessing welfare and proportionality, must be convinced it's necessary, the last resort, and that nothing else will do.
There's that phrase again, nothing else will do, now explicitly linked to the HRA proportionality test.
Exactly. It embedded it firmly in human rights law. After Re-B, the Court of Appeal sent several cases back because this test hadn't been properly applied, Reg G 2013. Re-B also made clear that appeal courts have a duty to check if trial judges followed Article 8 properly, leading to more scrutiny of these major decisions. Article 8 also underpins the duty to promote contact, HKV Finland 2006. The bottom line from the HRA is that state intervention must always be proportionate. F.A. Child, 2018.
So the HRA acts as a powerful check, demanding necessity, proportionality, and procedural fairness from both authorities and courts. It's woven throughout the whole system.
It absolutely is. It influences how the Children Act framework is interpreted and applied in practice.
Okay, we have covered a huge amount of ground in this deep dive, really mapping out the legal landscape for children and local authorities in the UK.
We certainly have. We started with that core philosophy of the Children Act 1989 non-intervention, support, partnership, keeping links. Then we looked at the specific duties for children in need under Section 17, covering support services and the limits on enforcing those duties.
We got into voluntary accommodation under Section 20, the mandatory duty criteria, that crucial parental right to remove under Section 28, and that fascinating case law tension between Munby's guidance in Rien and the strict statutory reading in Williams v. Hackney.
Then we moved on to duties for looked-after children under Section 22 and Section 23, stressing the need to consult and consider the child's background and wishes.
We looked at the investigation trigger, the Section 47 duty, and the toolkit. The evidence-seeking CAO, S43, the urgent EPO, S44-45, with its temporary PR, and police protection, S46.
We spent a lot of time on the crucial threshold test for compulsory orders in Section 312, defining harm, significant harm, the timing for is suffering, REM, Northens vs, and the likely to suffer test needing a real possibility, proven on the balance of probabilities, Newham v. AG.
And we tackled those complex unknown perpetrator rules, guided by Re-H&R, Re-B 2008, Re-SB 2009, and the vital clarification in Re-J 2013.
We covered attributability linking harm to care below a reasonable standard, including the Re-B 2013 point about character, or the child being beyond control.
Then the vital welfare stage, applying the Section 1 checklist, the no order principle, and that overriding HRA proportionality test. Nothing else will do from REBI 2013.
We distinguished final care orders, S33, which grant shared PR, from supervision orders, S35, which don't, and discussed care plans and Article 8 challenges post-order, REGI, REDE.
We covered contact for children in care under Section 34, the duty to promote it, the court's role, and its limits, NOTS VP.
And finally, that whole mosaic of accountability, discharging orders, S39, complaints, JR, civil actions, and crucially, the Human Rights Act 1998 demanding proportionality, REB, and accountability for failures, ZVUK.
It really is a comprehensive legal framework, albeit a complex one.
Absolutely. For anyone studying this, especially for exams, make sure you can define those key terms. Child in need, significant harm, threshold tests looked after, know the key sections. 17, 20, 31, 34, 38, 43, 44, 45, 46. Understand the difference between interim and final orders, care and supervision orders, and crucially explain the principles from the big cases. Re-B on proportionality, Re-SB and Re-J on unknown perpetrators and future risk. Working through problem questions, applying these rules and principles is probably the best way to cement your understanding.
This deep dive really underscores the complexity and the huge human stakes involved when the law governs interactions between local authorities, vulnerable children, and their families. It's that constant balancing act, protection versus family autonomy.
It is, and it shows that while the statutes provide the structure, applying the law in messy, real-life situations, often with incomplete facts and high emotions, demands rigorous legal analysis, awareness of case law, and a constant focus on human rights.
We really hope this deep dive has helped you navigate these sources and feel more confident about this critical area of law.
And just a reminder, these materials were made available for educational purposes by the University of London, and this deep dive was brought to you by Sinorbit Academy, Sri Lanka.
We wish you all the very best of luck with your exams and your ongoing studies.
And perhaps one final thought for you to take away and mull over. Given those inherent difficulties gathering evidence inside families, predicting the future, as Herring highlighted in cases like RESB and REJ, grappled with how truly effective can this legal framework be in consistently getting that incredibly difficult balance right. The balance between the state's duty to protect children and the fundamental principles of non-intervention and respecting family life. It's the core dilemma, isn't it?
It really is something definitely worth pondering. Thanks for joining us for this deep dive.